Hello everyone, it's Rick. It is March 27, 2017, my birthday. And you can reach me at rick0327 at me.com. Okay, and what I'm showing here is Chapter 7. Essentials for attorneys in child enforcement. It's funny how they don't say child support enforcement because they probably can't. Anyway, these are they're like the handbooks for all the attorneys to follow the endless procedures they're supposed to follow to steal your money. And if they don't follow them, they're violating their own due process, and it renders their orders defective. Okay, so one of our tools at trying to get these people to provide evidence of a debt, evidence that you owe money, is by interrogatories. And I provide interrogatories, and many people are finding, or they're getting the responses from these scumbag attorneys who think they're so fucking smart. But your boy Rick right here got something for their ass that they can't deny any further, and we're gonna cut them off. We're gonna cut their balls off. Okay, what I discovered in Chapter 7 was the uh, the child support enforcement. They advocate discovery by, let's go and see where we're going to find page 104. Here we go. Here we see there, guys and girls. Interrogatories. Look what we got there. Interrogatories, like requests for admissions. Interrogatories can be served on any party at any time after service of process without leave of the court. In many jurisdictions, a set of interrogatories can be served with the initial pleading. Time limits for filing answers vary. Okay? This is them. So they're telling their attorneys to use interrogatories to get discovery from you. Okay, except what we're doing now is we're flipping the script. We're going to say, okay, well, you need to show me proof that I owe you, proof of a debt, validating this debt, proof of an undertaking, proof of a money judgment, a writ of execution, writ of garnishment filed with the clerk's office, as you're supposed to do when you're following due process. Okay, here we go. Interrogatories can be used to narrow essentially uncontested issues in a fashion similar to requests for admissions. More importantly, they can provide information regarding the financial situation of the parties. That will be helpful in setting the amount of child support obligation. So what they're doing here is they're going to send this to you because they know they can't send the warrant, even though they're supposed to do this by a warrant, because under the Fifth Amendment, you must not provide testimony or evidence against yourself. So the criminals that created all of this stuff, they what they do is they get us. They tell you have to fill out these financial disclosure forms. They trick you, and they use interrogatories. And now here's what happens. You are, maybe you're provided with an attorney, okay? Or you hire an attorney. What you don't know is that the attorney doesn't work for you. The attorney works for the court. Now, I think it's chapter 1 here, but it basically, the role of the attorney. They write it in such a way that the attorney does not work for you. The attorney works for the child support agency. So therefore, the attorney working for your ex-wife, your baby mama, whatever, and your attorney They're working for the same goal. That's why, a couple people have an attorney and like they'll send me an email and I'll say, well, you tell them that you're not going to fill out the financial disclosure form. And the attorney gets mad. Or the attorney's threatening to quit. Because the attorney is working, they're both working to get this thing done that you're screwed and paying child support. That's their job. But what I'm doing here now, I'm using this to say, okay, you have to respond. Now I'm going to show you here. This, my man, Certified Slim here. Okay, look what we got here. Dear Mr. Yarbrough, enclosed, please find the interrogatories that were served upon the Indiana Department. Now watch how slick this guy is. He's not that slick. He's probably stupid. These attorneys aren't nearly as smart as they want you to think they are. Okay, hold on a second here. Let's see if I can fix this. Okay. Now watch this here. Served upon the Department of Child Support on March 6th, pursuant to Indiana Trial Rule 33B, which, by the way, Indiana Trial Rule 33 is a mirror of Federal Rule 33. The Indiana, by the way, trial rule is for courts. The Indiana Department of Child Support Services, they're not part of the courts. They're an executive agency. So I got something for this guy's ass. And the only way that I know how to write. The Child Support Bureau objects to these interrogatories on the grounds that they fail to follow the format requirements in Rule 33B. You know what it says in 33B? It says it's supposed to be numbered. He didn't do anything wrong. It's mine. I wrote it. I followed their requirements. So this guy's talking out of his ass. Further, the Department of Child Services, Child Support Bureau, objects to these interrogatories on the grounds that they fail to comply with Indiana Trial Rule 26. Again, a mirror image of Federal Rule 26. Okay, now I'm going to show you something. Indiana Trial Rule 26. Okay. Discovery, right? Non-attorney personnel conduct much of preliminary investigation in child support enforcement cases. After an attorney has filed an action, however, he or she can employ more formal discovery devices. Federal Rule 26 is the word for word what Indiana Trial Rule 26 is. That's how slick this guy thinks he is. So now, what I did was I flipped it on him. Let me see what we got here. Okay, let me show you how your friend Rick here responds to these pieces of shit. Okay, Mr. Hale, do you understand that fraud is a serious crime? Mr. Hale, do you understand that your efforts of concealment of evidence of fraud is a very serious crime and nullifies any qualified immunity? See what Mr. Hale here, the attorney, what he's doing here, not only is he objecting to the interrogatories, but see, he's claiming that he doesn't have to comply because of Indiana Trial Rule 33 and Indiana Trial Rule 26. What he's doing is he's misrepresenting facts. You know what that is? The misrepresentation is fraud. Word for word is fraud. Whenever you misrepresent something, it's a fraud. This clown is committing fraud right before our eyes. So everybody that's watching this video, you're witnessing a fraud. Okay? It's a fraud. And I'm telling him that. Mr. Hale, question 3. Do you understand that deprivation and conspiracy against civil rights pursuant 18 U.S.C. Section 242 is a very serious crime and nullifies any qualified immunity? Mr. Hale, do you understand that there is no privilege against arrest for felony crimes for attorney representing a state agency and nullifies any qualified immunity? See what I'm doing here? Is I'm flipping it on him. I'm telling him that, oh, you know that you think that you're slick by saying that you don't have to respond to interrogatories, even though Chapter 7 here advocates attorneys. Now, he's an attorney. Look, attorney for DCS, Department of Child Support. He is one of these attorneys right here. So he's supposed to know this. So what I'm going to have my friend here do is when he sends this response, he's gonna print this out and he's gonna send it to him. He's gonna attach it to this letter, this response. Okay, Mr. Hale, as a legal representative, you should understand that Trial Court Rule 26A is a court rule that states you must comply with written interrogatories. This idiot says that he doesn't have to comply. He doesn't say why, but the 26 says he must comply. Okay, let me see. Let me find it. I'll show it to you real fast. Okay. Nope. What we got here? Hold on, guys. A second. Okay. Okay. This is the copy. Federal Rule of Civil Procedures. This is 33. Okay. Where is it? 26. The duty to disclose general provisions governing discovery. Parties may obtain discovery regarding any non-privileged matter that is relevant to any party's claim or defense and proportional to the needs. Where the hell is it? I'm sorry. Answers and objections. A responding party interrogatories must be answered. Okay, they cannot. 26B, interrogatory is not objectionable merely because it asks for an opinion or contention. All right? He doesn't know what he's talking about. He just buried himself, this guy. Okay? So, what I did here, now this is the child support interrogatories that you get when you get the package from me. And what I did was, because I discovered this, see, I'm always about finding information. My methods are geared towards understanding that we got to get this fixed as soon as possible. We can't be sparring with these people for a year, because a year is 12 months. 12 months is 12 payments of child support. All right, I had a guy reach out to me. He's into he helps people as well, and he was trying to help me, and he wasn't wrong in what he was saying. But what I was explaining to him was, I can't get involved in these debates with these people about I'm not a citizen. I'm a people. I'm a man. I'm a woman. We can't get involved in these, because there's a bunch of people out there who believe that the 14th Amendment makes us slaves because we're citizens. We're not a man. You know what? I'm not going to get into that debate. And that debate also is mentioned in that Lawless Ones manual. And the FBI, those robots, are programmed to think that whenever somebody, they'll say is a sovereign citizens, their methods are, or their basis for their arguments are, the 14th Amendment it makes them a slave because it makes them a citizen, that whole argument. Listen, we don't have time for that. We got to get this fixed. Okay, so I'm staying away from anything that which may cause one of the clerk people to send your paperwork back, the fake judge, the judge, anybody to label you a name. We're trying to avoid this stuff. That's what I'm trying to do. And I'm trying to beat these people with their rules. Okay? This is their rules right here. So if they're being told, the attorneys are being, the essentials for attorneys and child enforcement is advocating using interrogatories, then we're going to use interrogatories ourselves. And what I did was, because I discovered this yesterday, I now added it to the interrogatories. Anybody who has my paperwork already, you got the video right here. All right. What I did was I said interrogatories are a widely accepted discovery method and advocated as a discovery method for child support attorney and the Child Support Enforcement Agency in Essentials for Attorneys for Child Support Enforcement, Chapter 7. Therefore, if the Child Support Enforcement Agency is advocating discovery by interrogatories, then it must be willing to reciprocate, meaning when they're presented with interrogatories, if they're going to use interrogatories, then they should be willing to respond to interrogatories themselves. Because remember, and they're not doing anything wrong, right? In their minds, they say you owe them money. It's their belief. Okay, well, you have every right for discovery of evidence by interrogatories. Okay, so I just added this. So you know what that means? When they get this, the attorney cannot, I'm eliminating this timely thing now, like, this bullshit here by this piece of shit. Because now, my man, Certified Slim here, he's got to go waste 2 or 3 weeks sending a mail, waiting for a response. So what I did now is I eliminated that. And Certified here, he just contributed to our course. Okay? He's a beast. He shared this with me, and I looked it up, and that's how I was able to find this, and that's the reason why I'm doing this video today. Okay? So, I added this. I added the link. Okay? Anybody can add this to the paperwork if you have it already. Okay? All you got to say is, here we go. Therefore, when the time comes for interrogatories presented by an alleged debtor, that's us, or obligor, that's us, for discovery of evidence proving validation of debt or an undertaking for support payments. Remember the undertaking the other day. Remember, that's another discovery thing that we're looking for, because an undertaking is an agreement. You cannot be an obligor or a debtor without a contract. Remember that. So we're asking them, where is my signature, your signature, our signature, that we agreed to pay an obligation through child support enforcement? Because child support is voluntary. They don't want us to know that. That's why that's the whole reason for that fake fucking court hearing. That horse shit. All rise. Raise your right hand. It's all for show, to make you think you must pay. But you do not have to pay, because they're calling us an obligor. They're saying you have an obligation. You're a debtor. You cannot owe a debt unless you agree to a loan or an obligation, or you agree to services. Now, these slick bastards, what they did was, your baby mama is supposed to be on welfare. Now, how is she allowed to assign her support rights over to them is beyond me. I don't know how that's legal, because she's the one that made the deal. So how is she making a deal and then assigning it to a third-party collector, child support enforcement, and now they're trying to collect this debt? They're not allowed to. It's illegal. It's illegal. That's why I keep saying, some of us, after we have exhausted all of these methods, may have to go to the police, because we're dealing with criminals. I'm hoping this doesn't happen. I'm hoping they throw their hands in the air and just finally give up. And using this right here, this method right here, Chapter 7 here, advocacy for child support enforcement attorneys. What they're advocating for them to get information so they can better steal your money. All right? Well, we're doing the same thing. We're asking them for discovery of proof that you're a debtor, proof that you're an obligor, proof that you owe money. proof of an undertaking. Okay? And how are we doing that? We're doing that by this right here. Interrogatories. And I added it. All right? So anybody that wants to get the paperwork, you reach out to me, rick0327@me.com. All right, I just showed you the response by right here, this clown, right? This is a routine response by these slickster attorneys that aren't as smart as they think they are. Okay? This is the only way he can resort to responding to the interrogatories. And it's not a very good, he didn't do a very good job, guys. You see that there? That's not a very good job. Okay? Because that's why I got something for his ass. Okay? So, Mr. Hale, pursuant Chapter 7, Essentials for Attorneys in Child Support and Child Enforcement. I don't know. There's got to be a reason why they won't say child support enforcement, because it's illegal. A discovery method encouraged, I should say advocated. Hold on, let me fix that. Method advocated. Advocated by this chapter is interrogatories under Federal Rule of Procedure 26 and 33, which you claim does not apply, and clearly your attempt at misrepresentation of the law and evidence of your advocating fraud by concealing fraud by refusal to comply with the discovery method advocated by Essentials for Child Enforcement, Chapter 7, page 103. And what I did was I copied and pasted discovery. Non-attorney personnel conduct much of the preliminary investigation in child support. After an attorney has filed an action, however, he or she can employ more formal, we did this already. And I'm showing him that if he's being told to use this method, we're allowed to use this method. Okay? And I showed you the questions where so I want to see how he proceeds now. He has no other choice but to proceed by answering this, because I just showed him this. And it's also proof that these interrogatories work. Okay? And is this just another swing of the axe that knocked the trees down? Is by using this. This is key right here. This is huge. I'm so happy I found this. Now, you want to know how I found this? All right, I'm going to show you guys something now. I'm going to show you. Anybody can use this. It's a free tool. It's called Scholar Google. It's like a law library. Okay, so what I did was I put in, where is it? I put in child support enforcement agency interrogatories. Right? And that's how I came up with Chapter 7. Now, I'm not going to come up with it here because I didn't do it that way, but I'm showing you what I did. But this shows all kinds of law articles. It's a fantastic tool. Okay, so now look, I'll show you another thing. Void judgments can be attacked at any time. All kinds of case laws can come up. Right here, case law. Boom. Case laws. Articles. Boom. This is huge. So anybody out there, instead of emailing Rick, you can use this, okay? It's free, okay? Right there, Scholar Google, or Google Scholar. And you just add it to your your favorites bar. You know, bookmark, you add it, add bookmark, right? Favorites, and you're there. It's another tool. All right. So listen, I hope you guys learned something. I hope you learned that interrogatories work. And I just, took that. I just saved some more time by showing these people that they got to respond. Okay, they were using all kinds of stupid reasons they cannot respond. But as you see that dumb response by the attorney, what does that tell you? It tells us that we're right, and it's showing that they have no reason to steal our money, and they're using any little dumb reason they can to not cooperate. All right, but when you start calling an attorney who's not cooperating, who's supposed to be an officer of the court, who's supposed to be sworn to the Constitution. Now listen to that. Listen to that. Officer of the court, right? Officer of the court. What is he doing? He's lying. He's concealing a crime. That's very serious stuff. And I'm calling him out on it. Let's see how he responds. All right, guys, listen. Enjoy the rest of your day. I hope you learned something. All right? I'm going to go enjoy my birthday. I'll talk to you guys later.